Protecting our personal information, like medical information or financial information, is something that we learn to do early on as adults. The reason is because information is power, and not everyone has our best interests at heart. The Federal Communications Commission is reviving a policy that allows it to collect employee data for its own purposes. Now, why do they want this information, and what do they intend to do with it? Joining me is Abraham Hamilton III, General Counsel for AFA, to explain that. Hi, Abe.
How you doing, Jeff?
Tell us what's going on over at the FCC.
Yeah, as you've described it, the FCC has decided to resurrect a policy that they attempted in the 80s and the 90s to require all broadcasters, that would be television and radio broadcasters in the country, commercial stations and non-commercial stations, to collect demographic data for all of their employees and to include it in its public online station file, which will allow third parties, outsiders, anybody to see this pertinent personal information for broadcasters. In the 80s and 90s, the FCC tried this, unsurprisingly, under Democrat presidents, and the courts rebuked them as unlawful invasions of privacy, violations of equal protection under the 14th Amendment, Section 1. However, the Biden administration has gone a step further. They're not only attempting to resurrect the data collection, but they're adding an additional category of data collection where they're requiring broadcasters, just like American Family Radio, to communicate whether or not we have gender non-conforming employees and how many of them we do have, and to specifically do so to allow outside groups to put pressure upon us to capitulate to the Biden administration's really, obsession with the LGBTQ IAP plus sexual deviancy social political agenda. So the ultimate objective, and this is not merely my opinion, this was stated by Biden administration officials during the deliberation stage before this regulation was made public, finally, that they want to use this regulation to force organizations to use hiring practices for people of the LGBTQ persuasion that they prefer. This is a part of the Biden administration's administration-wide mandate to look for every area they can advance the LGBT agenda, and that is what they're doing through this regulation.
So, in effect, the government is simply opening the door and allowing third parties to take advantage of that federal open door, then to create pressure. Give us a scenario on how that might be used against ministries like AFR.
That's exactly what they endeavor to do. Okay. And what they want to do is use the online station file publication process to pick out who they believe are winners or losers in terms of the broadcast community, and say these are the bad guys. It's kind of the broadcast version of the SPLC hate list.
Wow, that's scary. So this is the part of their overall DEI initiative toward corporations and other entities?
That's exactly right. It's a part of their overall commitment. And this is what the Biden administration, this is what they said coming in, that they would look for every opportunity, every context, every environment to advance this agenda, regardless of what the citizenry thinks, and regardless of what the employers think, and this is why the founding fathers warned us against having an expansive, overreaching government.
Yeah, I'm glad you mentioned that, because one of the things that we see is that government always tends to expand. And the very fact that there were courts that said no to the federal government 20 years ago, It seems that the Biden administration could care less what the courts say. They are bound and determined to push every envelope, to break every rule until someone stops them.
Does it sound familiar? I mean, the same thing happened with the rent moratorium when the Biden administration told private property owners that they could not collect rent for their property through the CDC. The same thing with the student loan cancellation. The Biden administration had attorneys in their own administration saying that this is illegal, but they pressed forward with it anyway. This is something that's happened over and over and over again, and the Biden administration is consistently demonstrating its disdain, really, for the rule of law, and saying that, well, this might be illegal, but if you don't stop me, we're going to do it. Yeah. So this is why we have filed a lawsuit to invite the courts to stop them, the same way we had to sue the Biden administration against their vaccine mandate, to where they were attempting to tell American Family Association that we had to require our employees to get the vaccines, regardless of their prerogatives. And we had to sue the Biden administration to stop that, which thankfully we won. Here we are again. suing our own federal government.
Okay, so you brought the suit before the Fifth Circuit Court of Appeals, which is based in New Orleans.
That's right.
A fairly conservative court. So when do you expect to have a decision, or where is this going to go from here?
Yeah, so we filed in the Fifth Circuit because that governs where we're located, you know. We're not forum shopping. That's just where we are. That's where we had to file. We're grateful to God that it is a law-abiding constitutionalist circuit court. Following our lawsuit, having filed ours, it gives real potential for the priority to be in the Fifth Circuit, to where our filing will govern where this matter will be litigated ultimately. But because there's such a wide swath of litigation all over the country, they're kind of entered now a circuit court lottery system to determine which circuit will be the lead circuit in handling this particular issue. We're hopeful and we're expecting the Fifth Circuit to ultimately be the venue where this matter will be held, but that remains to be seen. Once the circuit determination is made, litigation will proceed there. It is noteworthy because this is a federal regulation. We get to bypass the district court level and go straight to the appellate circuit, which would expedite the process if necessary to where the Supreme Court would hear it in short order.
I want you to speak to one more thing, because not everybody is a member of a broadcast entity. We're not radio owners, TV station owners, but there is a danger in giving too much information when it is asked of us on a form, whether it's from an employee or from the federal government. Could you speak to that just a moment? And because a lot of people think, there's really no harm in this, it's just innocent information, but it may be used against them in some way.
It certainly can be used against them. We have a pretty significant amount of employees, so this would be putting our employees' information within the federal government apparatus for them to publicize, frankly, for personal, private employees to have their personal information publicized publicly simply because of where they work. That is an invasion of privacy, and that is a violation of equal protection under the laws. But in addition to that, it could provide a roadmap and a blueprint for the government to expand its operations using the massive, I call it the Leviathan state, through the alphabet agencies, to get more and more access to the private information of everyday American citizens, because that is ultimately what this would come down to. It would be using the regulation to force us as an employer to require our staff members to provide their pertinent personal information for government usage for whatever purposes they deem fit, in addition to trying to compel AFR to capitulating to the DEI sexual deviancy social political agenda. It would be private persons having their information bandied about within the public discourse.
Okay.